All right, we're gonna get started. Just for the record, today is Thursday, March 16th, 2023. We're on voting list number 11. And we're going to start off with Shamari with Senate Bill 540.
Senate Bill 540 authorizes the Attorney General to investigate, prosecute, and remediate certain civil rights violations under certain circumstances. It authorizes the Attorney General to intervene in certain causes of action, establishes penalties, and authorize the Attorney General to obtain relief in certain civil actions, conciliation agreements, and settlement agreements. And it authorizes the Attorney General to recover certain investigation and litigation costs.
Shamar, am I mistaken, but are there amendments on this one?
There was an amendment that was received this morning. The request is in, just waiting for it to come back from review. I can explain the amendment.
Sure, let's do that. I mean,
okay, so if you look at page 3 of the bill, there's one amendment. The amendment would insert in line 7 after line 8, or sorry, after line 7, for any units of state or local government established by law, or for any employee or agent listed in this subsection who is acting under the color of law. And so that exempts individuals who are for any unit or state of local government and any employee or agents who is acting under color of law from being sued under this bill. And so the other part of the amendments, if you go to line 10, and in that line, on the same page, yes. It inserts subtitles 1 through 11 wording after the word under. So it would read, nothing in this part may be interpreted to impair the rights and powers of the commission under subtitles 1 through 11. And so subtitles 1 through 11 of the code, that just deals with, give me 1 second.
And Mr. Kemmerer, if you can ask you, but just with these two amendments, so I know there was the Maryland Commission of Civil Rights had, not an issue. They came and testified in favor, but maybe some clarifying language. But then also the state's attorneys expressed some concern, and I believe the two amendments assuage the concerns that they have by taking them out of that law enforcement definition. So if you could just expound upon that, explain that, and while Shamari looks.
Sure. Thank you, Mr. Chairman. Hannibal Kemmerer with the Office of the Attorney General. The first amendment that Shamari mentioned is intended to address complaints by the Maryland State's Attorneys Association. The second one was at the request of MCCR, and I think there's some other ones later. It's a total of like 4 or 5. But those are to address MCCR as well. Excuse me.
So the public safety article 3-201 is that's the state's attorneys, right? That they wanted to ensure that they're not. It's the definition of law enforcement agency in some parts of the code would encompass the state's attorneys. In some parts it does not.
Right.
So this is clarifying language to make sure that they're just taken out of the bill.
Altogether, yeah, that was actually the concern they expressed most prominently on the pattern of practice bill, but they did say they were concerned about individual state's attorneys being sued. And I mean, as you know, they're usually immune, but there was a case against Mr. Schellenberger where, you know, he was held, he had to settle. And so they wanted to make sure that there wasn't anything like that in this bill.
With these amendments, is MCCR and the state's attorneys, are they often, there's a kumbaya here, right?
As far as I know, Mr.
Yeah,
Chairman.
got it.
Can Mr. Kimura come back up?
Yeah.
I'm all right. That's nice that there was a kumbaya. I'm not sold necessarily as to why they should be taken out.
Well, I mean, we want to count the votes and we don't need to necessarily exacerbate the relationships between our office and the state's attorneys. And, you know, they felt, I think, like the prosecutorial authority was for our IID was a tough pill to swallow. So in Annapolis, you always hear the phrase, you pass, you know, deals, not so much laws. And we're happy to try and blunt the opposition there.
So if they're engaged in some activity that needs to be addressed, you all won't do it. And if I remember correctly from the testimony, it's left up to who?
MCCR, or, you know, an individual could hire their own counsel. That's also true. Or EEOC.
Okay, thank you. I'll see it. I'll check. I want to see the language.
Thanks.
Yeah, I just want clarification, and Mr. Kemmer can answer, or maybe committee counsel can better explain it to me. So the language of this gives the authority for the Attorney General to prosecute certain cases. And then with regard to the subpoena power, there's a line in here that says that information obtained under subpoena is not admissible in a later criminal proceeding against the person who provides the evidence. So I guess the question is it possible that beyond this, that there could be is there a scenario where the subject of the subpoena could commit perjury and then be barred from a later prosecution for that? Is that something that could happen under this language?
So, Senator Carter, thank you for the question. The reason we put that language in there was because if you have parallel proceedings and in the civil case, you compel somebody to provide you testimony or information, and then you use that same information in a criminal proceeding, that it could violate that person's Fifth Amendment rights. So just to be in an abundance of caution, we put that language in there. It doesn't prevent, for instance, if our investigators come across something, interview a witness, the witness lies, and it doesn't prevent, you know, them referring that to criminal authorities, but they would have to get, you know, independent evidence of the violation in order to prosecute.
Thanks. I think that clears that up. Because I was going to ask where else we have that express. Is there other areas in similar kind of administrative or proceedings that we do that? We state that.
I'd have to
explicitly?
take that question with respect to Maryland, but I know the feds do. They definitely in their investigative authorities at the Civil Rights Division have a similar prophylactic language, and some other states do.
Thank you. And then also I want to echo what Senator Sidnor said. I don't know that we should have gone with those amendments. That's just
Well,
my opinion.
We defer to the committee's will.
Thank you, Mr. Chairman. The Maryland Chamber also was against this in a different part. Shamari, did they weigh in with any kind of amendments or anything like that, sir? None, because their concerns was that it rewrites writes Maryland law for standards seeking injunctive relief. Section 20-1046 authorizes the reimbursement of the Attorney General or the Commission on Civil Rights for the cost of investigation and litigation. So, just FYI.
So Shamari, the rest of the amendments you have do you finished up?
So there's also a part of the amendment that if you look on page 4 in line 15. And the amendment would strike the word information and substitute unless obtained by a method independent of a subpoena. And so the part C would read, unless obtained by a method independent of a subpoena, information obtained under a subpoena described under the section is not admissible in a later proceeding against the person who provides the evidence. And so that seems just to be for clarity that if there's information obtained in a different way, then that would still be admissible, but just the information obtained by way of subpoena wouldn't be able to be used in a criminal proceeding.
All right, let me ask you this. So these, these amendments are still under review right now?
Yes,
So what does that mean? When do we?
any minute now, or it should be fairly soon.
Yeah, all right, we're gonna hold the bill until we get those amendments. We need something before us to adopt, so. It's. People need to be able to read something to adopt it. All right, so if, as soon as they come in, could you please let us know and then we'll pull the bill right back up. Okay, let's go on to Senate Bill 254.
Senate Bill 254 alters the definition of charitable contribution to exclude a donation of property that is intended to be redistributed without charge for a charitable purpose, and an authorization for or discount on the use of services, materials, equipment, or facilities. There is an amendment in your packet. I think it was in your packet for a previous voting session. It's number 253927-1. The amendment would remove the donation of property from the definitional change being made by the bill, and it would additionally insert new provisions which authorize the Secretary of State to accept certain documents in lieu of an audit from charitable organizations that meet certain requirements as detailed in the amendment. My understanding is that these amendments were drafted in consultation with the Secretary of State's office.
All right, can we move the amendment just so we have something to work off of? All right. All right, everyone's okay? Go ahead.
I mean, yeah, again, my understanding was the amendments were worked out between the charitable organizations and the Secretary of State's office.
Could you explain it?
So I think the issue was that certain charitable organizations which don't have a lot of staff or do a lot of work were subject to certain audit requirements with the Secretary of State that they were saying were extremely burdensome. So the initial idea behind the bill was to simply remove certain things from the definition of charitable contribution, so they wouldn't qualify as needing to go through the audit process. And I think there was some concern that that may have been a little too broad. So the amendments essentially strike some of the things that were being excluded from that definition and instead insert a provision which allows the Secretary of State at their discretion to accept certain kinds of documentation in lieu of that audit for charitable organizations which meet the requirements that are in the bill now.
Oh, yeah, my read of it is, as council said, you have smaller organizations, audits cost an awful lot of money. And so this is just a way that, they can comply with the Charitable Solicitations, Act without breaking their bank. So he's just giving us instead of doing how the original bill came in, which I would have had some problem with myself. I think this is a good resolution.
Thank you, Mr. Chair. So I keep hearing these ads on, I think it's the radio, for cars for kids. So if I have an old car and donate an old car, is the organization that I give the car to, is that going to be a charitable donation that I can take on my tax return?
It is.
It is.
It is.
Okay, because as I'm looking at this. Yeah, I know, I've heard it 1,000 times. So, but it says you got to do an affidavit attesting that the organization primarily solicits in-kind contributions. So I guess not, this organization would be primarily soliciting cars, right? I'm looking at, well, it's not numbered. It's on the reprint. So Secretary of State may accept other documentation, including an affidavit attesting that the charitable organization primarily solicits in-kind contributions.
Okay.
So that's what we're talking about here, right? We're talking about cars for kids that mostly gets cars.
Correct, although that's only one of the things you would have to attest to there. So and also, does not employ a professional solicitor or fundraising counsel. So you would have to attest that all of those things are true.
Okay, so if Cars for Kids did employ a professional solicitor, then my contribution of my car would not be tax deductible. Right?
No, so you're reading, so this part is simply about what the charitable organization has to do.
Okay,
So it's not on page 2 of the reprint is where we're changing the definition of charitable contribution. And I think the problematic language there, which was a donation of property that is intended to be
yeah, I
redistributed,
see. That's been deleted.
that was struck out of the bill.
Gotcha. Okay, thanks.
So there's been a motion for favorable, it's been seconded. Favorable with amendments, everyone okay? So Bill. Senate Bill 254 with amendment passes unanimously, okay. Senate Bill 645, Shamari, back to you.
Senate Bill 645 authorizes the mayor and city council, instead of the Secretary of Budget and Management, to set salary for deputy sheriffs and employees. It allows full-time sworn officers and court security officers to organize and collectively bargaining concerning salary, wages, hours, and other terms and conditions of employment that are determined, offered, administered, controlled, or managed by the sheriff and those managed by the city.
Is this the one where the sheriff came in and there was a dispute between them? Was that this one?
Yes, that's this bill.
Do we have a letter from the delegation? Oh, we don't.
No.
Right. I tried. All right, Senate bill. We just held it because we don't have a delegation letter. I thought we did. So Senate Bill 580, that's Jamie. Sorry.
Senate Bill 580 establishes the Officer and Community Wellness Training Grant Fund. It is a special fund administered by the Governor's Office of Crime Prevention, Youth and Victim Services. It's meant to provide grants to local law enforcement agencies for mental health, first aid, for public safety, training, and critical incident stress management peer support training. For fiscal 25 and each year thereafter, the governor must include in the annual budget an appropriation of at least 1 million for the fund. The bill also establishes certain reporting requirements. There is an amendment in your voting packet. It would change the appropriation language from a mandatory inclusion of 1 million and instead provide that the governor may include 1 million.
So just to be clear with that amendment, obviously BNT is blessed off and we're okay because we're not actually spending any money, or what is it?
It goes to be, it's BOT is secondary.
There's,
too,
okay,
but
BNT secondary.
but did they give us preliminary approval for that? Or because it's not spending any money now, or is that, how does that work?
Well, I mean, it's not spending any money right now, but ultimately, like, as the secondary committee on it, they'll decide whether or not.
To get back to their committee. And I guess they'll figure out the money side. So can we just, motions to adopt the amendments before you? All right, it's been seconded. Is everyone okay? All right, now the bill's before you as amended. Further discussion? It's a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay, great. Excellent. Okay, we're gonna go back to Senate Bill 645. Apparently, we do have a delegation letter. 645. So Shamari will come right back to you. 645. So yeah, sorry. Good idea.
All right, so 645 authorizes the mayor and city council instead of the secretary of budget and management to set salary for deputy sheriffs and employees. It also allows full-time sworn officers and court security officers to organize and collectively bargain concerning salary, wages, hours, and other terms and conditions of employment that are determined, offered, administered, controlled, or managed by the sheriff and those managed by the city.
All right, Senator from Baltimore City has made a motion for favorable. So it's been seconded. Vice Chair has a question.
Of course, I'm happy to defer to local bill, but so originally the sheriff's office testified unfavorably. Does a delegation letter mean that the sheriff is now on board? Or the
delegation decided unanimously that this bill was favorable. So I can't speak to that. I don't know if he's now on board, so I can't say that.
I can do that.
So we don't know if he's on board, but we're doing a measure that directly
I'm not
impact.
gonna say he is or isn't. I can't remember at this moment. If you want to hold it and let me check, I can. But I'm
Yeah.
assuming that if the delegation voted unanimously, that should take precedent. That should be
Well-
persuasive here.
I don't know that it should take precedent over someone running their own office. Because he's elected too.
Just for the record, it's taking it away from budget and management and putting it to the city, mayor and city council, the mayor. So it's not. I don't think it's.
I just have it written down that he was opposed. So I would.
Let me
feel-
check, hold it.
Thank you.
No, I mean.
I just don't remember.
Senator, happy to hold.
It's not my bill.
But you do have a delegation letter. I will act in deference to you and your
Right.
delegation letter. So whichever way you want to go is the way we'll go.
I want to
Chairman.
move it,
All right, then-
but because I don't want to be, I want the bill to be penalized because I personally don't know if
No,
it's.
you're not gonna be, it's a delegation letter. You have it.
Right.
Your delegation voted for it. I'm happy to move at your
Right,
deference.
there's usually all kinds of issues that people come up with, but once a vote has been taken, the vote takes precedent over anyone, and so that should be it. That should be it, and we all voice our opinion, but that's it too.
Senator from Baltimore City, what's your pleasure?
Wasn't this also an issue with, like, he just pointed out, I'm not reading it further, that it also dealt with the collective bargaining provisions. It alters some of the collective bargaining provisions for the full-time sworn law enforcement and court security officers. That also, so this bill would work with the salaries, fine, take that from DBM. But now it also alters certain provisions relating to the collective bargaining. And I remember that being an issue as well.
And the opportunities for the collective bargaining. So I think it's good for the workers. I think it's a good bill that, again, unanimous vote from delegation.
Senator Carter acting, you have a delegation letter. So what do you want to do?
Move favorable.
Okay. All right, we'll do a roll call. It looks like we'll do a roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
Pass.
Senator James,
Pass it on to me. Sure.
Senator Washington,
Yes.
Senator Kelly. Yes. Senator McKay,
Yes.
Senator Carter,
Yes.
Senator Folden,
I would like to go on the record as saying that I hope that we continue this type of support of delegation measures. Apparently, even though it may be in regardless of someone else's feelings to it. So, yes.
Chairman Smith,
Yes.
unanimous.
This is JPR. Everyone cares about everyone's feelings, okay? All right, all right. Senate Bill, so Jamie, read it back again. Hold on. Shamari, have we received the amendments? Or was that what you passed out?
Not the reprint yet.
Sorry, can you?
She'll copy that just went around.
Okay.
And waiting on,
Okay, we'll hold until the
it's
end.
not finalized. so
Got it.
we
We'll
can
hold to the
it.
end.
All right.
Okay, just wanted to check in. I didn't see what you passed out. All right, let's go on to Senate Bill 853, and then next will be Senate Bill 760.
53.
853.
So Senate Bill 853 alters the existing notification requirements for private home detention monitoring agencies. The bill requires these agencies to immediately notify the court that ordered private home detention monitoring as a condition of a defendant's pretrial release once the agency has determined that the defendant has been missing for 24 hours. If the court that ordered the monitoring is not open for business when the notification is required, the agency must instead notify the duty judge of the county where the court is located. The agency must immediately notify the Division of Parole and Probation upon determining that a defendant who is subject to private home detention monitoring as a condition of probation has been missing for 24 hours. Under current law, these notifications are made on the next business day. There's one amendment in your voting packet that just went around. If you turn to the reprint, On page 2 of the reprint, it provides that instead of notifying the designated duty judge of a county where a court is located in the event that the court is not open, the agency is instead required to notify the designated law enforcement agency in either Baltimore City or the county where the court is located, and the court immediately on the court opening for business. It also makes adds new text to the criminal procedure article. It provides that a person monitored by a home detention monitoring agency may not violate a condition of pretrial release if the person is charged with committing crimes of violence, crime involving a firearm, an antique firearm, regulated firearm, or a handgun, a crime against a victim who is a person eligible for relief. So that would be a protective order, or a violation of 3802 of the criminal law article. A person who violates that provision would be guilty of a misdemeanor and on conviction, subject to imprisonment not exceeding 90 days. Finally, in the reprint, the bill contains uncodified language that creates a work group on home detention monitoring. Subsection B of that uncodified language provides for the membership of the work group. The work group is required to study licensing, regulation, oversight, notification, and enforcement processes for home monitoring. That should say home detention monitoring in the state, and make recommendations for a cost-effective and streamlined process for home monitoring in the state. They are required to report their findings to the governor and General Assembly by December 31st, 2024. And that's the amendment.
We got Senator Washington and Senator.
Yeah, thank you. I appreciate the amendment and the work group. The work group targets the state. I kept hearing Baltimore City and Baltimore County courts though,
So I think it probably could be cleaned up in the language to what that's designed to do is to say that it's the designated law enforcement agency in either the county where the court is located or Baltimore City. So I think that was an attempt in the drafting to just distinguish between Baltimore City and not being a county.
Got it. But so this bill does apply across the state?
It would.
Yeah. Okay, cool. So I think there was some confusion as it came in that it was just for Baltimore City initially. But it's not, it's for the state.
Right. With that amendment, it's throughout the state.
Got it. Thank you.
Senator Carter.
Thank you, Mr. Chair. I want to make sure that I understand the bill as amended. So I think that I'm reading right, and I think I'm understanding it saying that if a person that's monitored by home detention violates any condition of pretrial release, Jamie, is it any condition of pretrial release? I understand if they're, so it's like distinguishing, like if you're charged with certain specific crimes and then you violate it's not any crime.
Right. So that new language in 5213.2, is that what you're looking at?
I'm looking at the amended.
Right.
Yes.
Right.
Yes.
So, right, that would say that if you are monitored by home detention monitoring, the prohibition is on violating a condition of pretrial release. If you are charged with any of those 4 offenses that are enumerated. So it doesn't specify what kind of violation. Right.
Could be any violation. So, just on my cursory look at it, I'm not anticipating persuading anyone here, but I'm not in favor of this. If they're charged with these crimes, and they're going to be held accountable for these crimes at some point. So violating pretrial with no specificity, the condition of pretrial could be anything. It could be you didn't call in or something, right? Is that correct?
If I guess if that was a condition that you were
It could be any
sure.
condition. There's no specificity as
it's not
the violated
specified.
condition.
That's correct.
They're already facing time for the underlying crime. So I mean, on my cursory, my cursory understanding of this, I'm inclined to be against it. What was the amendment, a sponsor amendment, or was it a committee amendment?
Oh, no, this was not a committee amendment.
Okay, thank you. Well, it's a no for me.
Um, I'm, what I was curious about was, in looking at page 2, under line 12, why the, we're removing the notifying the duty judge, and I mean, I get why we want to notify law enforcement. But why would we remove the duty judge from getting the notification and then waiting for the court to be open the next day?
Right, I believe that was in response to concerns that had been raised by the judiciary about implementing that.
Okay.
What
Okay,
are those concerns? Did you feel Sharon?
Let me get that up.
and while you're looking that up, I think I'm gonna echo what my colleague said. I was good with making the modifications that we were notifying folk immediately, but I didn't know that the amendment was going to go and essentially make it a crime to violate your pretrial condition. I mean, I think that's a little troubling.
Get clarity. So this is just an amendment post the hearing, right? So meaning we didn't contemplate at the time of the hearing adding a new crime. Generally, if a person violates pretrial condition, the court has the latitude to bring them in and say, well, you know, you ruined your opportunity to be on community detention or whatever, we'll bring you in. I don't know that any violation with no specificity, I don't think it's appropriate to say it's a misdemeanor. Just generally and broadly. So I would go with the original bill for the notification, but I think this is going a stretch too far, especially since I don't think we heard a bill about a crime.
Senator, I'm gonna have Jamie clarify, and then we're gonna go to Senator Muse and then Fulton.
So looking at the judiciary's opposition, they indicated that pretrial monitoring in each jurisdiction, including Baltimore City, handles after hours duty assignments for the circuit and district court differently. So I think it had just more to do with their right, that it would be going to the duty judge. It seems like it was more of an administrative issue for them in how they handle their staffing for off hours assignments.
Thank you.
I don't know a whole lot about the pretrial conditions, but when you say violate a pretrial condition, what can some of those conditions be, and what's the worst that can happen in light of this bill?
Broad range. Work, go to school. It could be report, you know, when you're supposed to report, it could be by phone or virtually or in person.
Drug testing, anything?
Drug testing.
Okay, got it.
It's a myriad of things. And depending on the specific situation, it could be like something specific pertaining to the person, not even the general thing. So like, I think, you know, that's difficult because like, when you think about working, going to school or things that could, you know, interfere with that, for just
Okay.
a myriad of things. I think it's too broad.
Thank you.
But again, I think this is not the original bill, right? So I'm in favor of the original bill. I think the amendment is troubling.
Thank you, Mr. Chair. So for what it's worth, I just wanted to make sure, like what Senator Carter was saying, is that there's already a remedy in place should we need to recall someone for violating the terms. I don't know that making it a crime, by the way I'm reading this, is a necessary addition because they're already in violation of a crime, and if they violate the terms of their release, then they at that point, it would be incumbent on the judiciary to then place them in Gen Pop versus allowing them another. I mean, that's their decision. They can, or they could, you know, give them another chance. But I don't know that adding a crime was the intended. I'm curious.
I've spoken to the sponsor about the amendments, frankly. I have not. So I don't know what the intent is, but look, I mean, look, that's not what we had the bill hearing on. It's not what the discussion was during the
Yeah.
hearing. So why don't we take the immediately language and why don't we take the judiciary's recommendation and then scrap the rest?
what was the judiciary's again? I'm sorry.
And that's on, if you're on page 2 of the reprint.
Okay.
It's lines 11 and 12. You know, they struck out for designated duty judge of the county where the court is located. So we would strike that out, keep that struck. And then if you go above to line 7,
Mhm.
that's the other part that we were talking about immediately. So we would just keep those two, strike the rest. What do you think?
Yeah, I mean, the original impetus behind the bill was that we had an immediate response, not that we had to wait. Is that correct? So that we could have an immediate response. If they violate it, we can go out and grab them. And that's what we want.
The law enforcement agency would be notified, right?
Yeah, I mean, they'd be notified, you pick them up. Now, if they are committing another crime subsequent to that, that's a different story, but
Different story.
the violation of it, of the actual terms. I don't know.
Yeah, I think what you just said at least makes it presentable. And if he has a problem, they can do something else later. But pass it that way without the amendments.
The immediate.
Right, and I mean, outside of just that portion of the bill, I mean, I'm not opposed to section 2 either. If you wanted to leave in the work group I mean, if there's some need to study how these things are done, I have no problem with the work group.
Too, about the work group. Yeah. Just trying to get to a penalty for if they violate, you know.
Go ahead, Senator Jamie.
So the judiciary just advised that by creating a criminal violation, it actually gave law enforcement grounds to go after them. Currently, under the criminal procedure article 5213 or section 5213 of criminal procedure, handles that through a bench warrant process that provides a court may issue a bench warrant for the arrest of a defendant who violates a condition of pretrial release. So I think my understanding of this is that because the court needs to be notified and then issue the warrant, which gives law enforcement the hook to go after the violator. So otherwise, they're saying that you would need a crime. So there'd be probable cause of a criminal violation on which law enforcement could actually arrest somebody.
And if we revert back to the designated duty judge being notified, then that process would still be in place.
Presumably, the duty judge could issue a warrant.
And go back to the duty judge. I don't know if we want to make it a crime. I mean,
So now thinking more about it, I do understand the idea behind it, because normally if you violate, the process is you have to then go, parole and probation has to violate them. They have to send in front of the court. They have to wait for that process to unfold. So there's no immediacy that we're seeking for as law enforcement to have a legitimate legal arm to detain the person. So by adding this language, it allows them to immediately, while they see the violation, secure the person without violating their rights under the Fourth Amendment, and then take them to a judge immediately. So I think that, I mean, really, you could almost make this like a misdemeanor with up to 5 days in jail, like just a minimal amount, but it's still legal to effect an arrest and take them immediately in front of a judge. Because the reason we're doing is we don't want to add more time, but we want to recall them and if need be, incarcerate them depending on the egregious nature of the violation. So I understand that part now. And if that's something to make you feel a little bit better, it makes sense to me now. Yeah.
I don't really have any problems leaving it the way it was. I mean, it's not that big a deal. We're not adding that much to it. If we don't have to change it, I'd leave it like it
But that's
was.
the problem now. The problem is they can't go and do it immediately, which is the whole reason behind the bill. So if they don't have some incarcerable offense, it doesn't allow them to make an on-scene arrest. They would have to then go lose sight of the person or have someone follow them for an extended period of time, go and petition a judge to get then a bench warrant to recall them. So it's kind of, so if you do it this way and make it a 5-day offense, then you can still immediately address them. You can incarcerate, you can hold them, and then they at least get their hearing and it doesn't put law enforcement in a trick bag for the immediacy of the deprivation of the Fourth Amendment by seizing their person. That's what it goes into, now that I think.
Agree. I'm still where I was before. I'm still on the original bill. That's what we heard. If we found a need to bring this back in, then the sponsor should come back in next year with another bill to deal with creating a misdemeanor. I do feel like it's an allegation, even whether or not, even though the person has very little rights because they're on probation or whatever, and given a chance to be released pre-trial, it's still an allegation, and I'm not willing to say that an alleged violation can be charged as a misdemeanor just in an effort to seize them quickly.
That it's an immediate response because the allegation or the occurrence is happening then. And you gotta, I mean, again, I understand what you're saying. I appreciate that, but understand it only needs to rise to the level of reasonable articulable suspicion, which then gets them to the probable cause. And if they have PC at that point to say that that person violated it, then that's enough to recall it.
I understand. I'm still in favor of the original one. I'm
no.
not ready to move. Do what
Yeah.
you will. I'm
No, I
not
got
ready
you.
to move on this.
I understand.
Can you give us what the judiciary is advising us for now?
So the judiciary had advised that currently they can do after hours search warrants, but they're not able to do after hours bench warrants. I'm not entirely certain why. But so they do have a process for after hours warrants, obviously, but just not bench warrants.
So I'm with Delegate Carter on this. I'm Senator Carter, excuse me. Goes back to judiciary. I don't think it makes sense to create a new crime to violate someone. But I do think, but it is an odd thing that a police officer can view someone they know to be on parole or probation who is violating that parole probation and not allow the officer to take them into custody. That's what you want. You want community policing. Oh, I'm sorry. But even if they're on pretrial release, you want officers to be able to do that. But it seems like an odd end around to create a new crime in order to do it. We should allow that, but we shouldn't do it in this bill in this way with this kind of, circular mechanism. Right.
Quickly want to say that first, we did not see this bill. If we had seen this bill, we definitely would have weighed in. I haven't seen the amendments, but just from hearing what you're saying, number one, this person is pretrial. They're presumed innocent. They may have never been convicted of a crime ever, right? And we're proposing that there needs to be a criminal finding to permit an issuance of a bench warrant. I mean, if the bill itself was to issue a bench warrant, that would be a whole different story. And then the other issue that I'm at least hearing, if the violation of the pretrial in and of itself is severe enough to be a crime, that officer can arrest them.
All right.
So if that's
good. There you go. Perfect.
Yeah.
That's all. Thank you. We're close. We're close.
We're close, but the bill. Someone pending a bench warrant for a pretrial release violation. Or we can just move it over to the Office of the Attorney General's office and they can handle it to their.
All right, what's the? Hold on, okay, so go ahead. Senator Muse, hold on.
With the bill as it was, if there are any other issues for another year, but not hold the bill because they just move the bill without the amendment and go from there. That's a motion.
It's either that or one or the other.
So that would be, that would be a motion.
Hold on, I'm fixing it. Either just make a decision, but honestly,
Look, I'm in favor of the bill and what its design is, but it doesn't meet the language and the letters of it don't meet what we're trying to do. And I think it creates potential legal issues.
Okay.
I don't agree with it. Y'all want me to move unfavorable. They're trying to put me on the button.
Then you're seconding it.
All right, here we go. We're holding the bill. All right. Unless you want to kill it. You want to kill it?
He made a motion to move favorable.
So that's why. All right, we're holding the bill, We're on to Senate Bill 760. 760.
Let's get the satisfaction.
Senate Bill 760 prohibits a security guard employer from employing a security guard to provide services unless the security guard is certified. The bill also establishes or alters training, liability insurance, notification, and recertification requirements for security guards, and also requires security guard employers and agencies to report use of force incidents by a security guard to the Secretary of State Police. You have an amendment in your packet, which is number 863026/1. The amendment does several things. First, it lowers the training requirement for recertification from 10 hours to 8 hours. It clarifies certain requirements for security guard employers and agencies to make notifications regarding recertification or disqualification. It extends the time frame for reporting use of forces. And it defines the term use of force. And I understand there's an additional amendment that should be in there. So if you turn to page 11 of 13 of the reprint in the newly added definition of use of force, one of the things that constitutes use of force is any physical striking or attempted striking of an individual. I believe the term or attempted striking should additionally be struck out.
All right, can we move to adopt the amendment?
Are we adopting the amendment that he just said?
Yeah.
Striking out the.
Yes. All right, just so we have something to work on. Is everyone okay with doing that? Is there a second? Oh, everyone's good. It's been Senator Carter's made a motion for favorable. It's been seconded by Senator Folden. Okay, it's not been seconded by Senator Folden. It's been seconded by everyone else. All right. All right. Do we need a roll call or are we?
I'm still opposed.
Okay, so Senator Folden is negative. Everyone else is positive. So the bill passes with amendment 10-1. Shamari, do we have the amendments back yet?
Yes. I am printing out the.
Okay. Then we'll just go to, let's go to Jamie's Senate Bill 592, which is a quick one. It's just a reporting bill.
So, Senate Bill 592 reconstitutes provisions of law that terminated in 2022. Specifically, the bill requires that Department of State Police by February 1st each year must report to the Governor and General Assembly on the acquisition of equipment by law enforcement agencies through surplus programs within the preceding calendar year. State Police must include in a prominent location on its website a link to the Defense Logistics Agency's report listing excess Department of Defense property transfers to law enforcement agencies through the Law Enforcement Support Office.
Senator Carter.
Chairman Smith.
Yep.
How many times have you had this bill? I know, I feel like-
I've had this bill since I was in the House.
I
Yeah.
feel like I've seen this bill
Since I was in the House, yeah.
100 times.
Yeah.
I know, we're favorable. What's the going on?
So
What way we keep
it's
doing
just,
it
it's
again?
sunsetted. It's just sunsetted. So I'm trying to extend the report.
Right.
No, I got it.
Sunset disappears.
Yeah. Yeah. There's some motions for favorable. It's been said. Thank you, Senator Kelly. It's been seconded by Senator Sidnor. Is everyone okay being recorded in the affirmative?
Yeah.
All right. Excellent. I think now we have the amendments for Senate Bill 540. Shamari, we're going to go right back to you. Just do another recap, and then if you could walk through the amendments now that we can read with you.
So Senate Bill 540 authorizes the Attorney General to investigate, prosecute, and remediate certain civil rights violations. And so there's the amendment in your packet. There's a reprint that's coming around that you should have. And so if you go to page 3 of the reprints, and so that's adds 2 provisions. Under Part B, the Attorney General may not bring a civil rights action under this part against any unit of state or local government established by law or against any employee or agent of an entity identified in items 2 or 3 of the subsection who is acting under the color of law. And so that was meant to address the concerns of the state's attorneys. And if you look at Part C on the same page, subtitles 1 through 11, that just deals with the Commission on Civil Rights. And so what that does is essentially says that nothing in this section is meant to impair the rights and powers of the Civil Rights Commission. So moving on to page 4 of the reprint, again, that's unless obtained by a method independent of a subpoena, information obtained under a subpoena described under the section is not admissible in a later criminal proceeding against the person who provides the evidence. Essentially, if there's evidence of other criminal wrongdoing in the subpoenas that are issued by the Attorney General, and then it wouldn't be admissible in court unless it's that information is obtained through other means. So if you move next to page 8 in lines 13 and 14, in areas of overlapping jurisdiction, the Attorney General and the Commission shall coordinate and make referrals to minimize and eliminate duplication of effort and promote collaboration. And so those just adds a couple words for clarity, and that's the bill.
So to move the amendments, we can discuss it on seconded. Is everyone okay adopting the amendment? All right, now the bill's before you is amended. Discussion.
Go back to page 4 and C and give me a little more clarity on what that means or who it would affect or.
So
And
if the Attorney General issued a subpoena and gets back information like of another crime that they weren't investigating,
Committed by.
I guess anyone, whatever the
Okay.
information reveals, and so that wouldn't be admissible in a subsequent criminal proceeding if charges were filed that from the subpoena. But if it was achieved through other means, like another investigation or, the prosecutor went out and got evidence from like an
Judge.
independent witness, then, that would be able to be used in the proceeding against the defendant, but information obtained just by the subpoena, that's not admissible.
Okay, got it. Thank you both.
Senator Folden.
Thank you, Mr. Chair. Can you just give me, Shamari, an example of, I just want to make sure I clearly understand this, so. Or someone, on page 3. Section B, and then we're line 4 or section 4, subsection 4. Against an employee or agent of an entity identified
So,
of this subsection who is acting under the color of law.
right, under the direction or guidance of,
So if a police officer,
mhm.
is this a part of where if they're acting under the color of law that the Attorney General may not bring civil action? As long as they're acting under the color of law?
That's how it reads.
Because 2 and 3, I'm sorry, not even 2 is irrelevant, but 3 was the added part of any unit of a state or local government established by law. So
Mhm.
that would include all your local law enforcement. Okay, I'm just gonna be quiet.
That's my reading of it.
Okay. I just want to make sure that I read it clearly because I am not an attorney. I'm just making sure.
As long
Thank
as, the officer is acting under color of
Under the
law. if
color
it
of law,
was
right.
Some other act that,
And if he's
isn't
working
appropriate.
within, I mean, generally in any lawsuit, there's 2 questions. Do you train and did you do as trained? And those, if you can answer yes to those, usually you're acting under the color of law. So thank you.
On the same set, on that same line. And again, so it says, the Attorney General may not bring a civil rights action under this part against any unit of state or local government established by law. Why would we agree to that? I mean, I'm over in one of the other committees because of what Baltimore County did with its voting rights violations and trying to give the Attorney General power to deal with that. So I mean, that's a civil rights violation. Am I reading that right? So they wouldn't be able to address that type of civil rights violation? Am I misreading it?
So what would your example be? Or I guess.
Thanks, Senator
Mr. Moore
Sidnor.
wanted to address.
So Hannibal Kimmer for the record, with the Office of Attorney General. Yeah, I mean, there are other ways to address civil rights violations by police. You can do it through 42 USC section 1983. You could do it through malicious prosecution under state law. As an individual, you can do those. This is just saying the Attorney General, with all of its resources, can't bring a case against an individual police officer or.
No, but what I'm talking about goes, because this goes beyond police, right?
Yeah, right. It goes,
So
it
in the
includes state
case where
attorneys.
Baltimore County creates a discriminatory map in doing redistricting, this hamstrings you all. Y'all can't get them, right?
That's true.
Yeah, no, thank you.
Yeah, I mean, there are other remedies. You could sue under the Voting Rights Act. Doesn't have to be in this particular bill.
Delete them.
Yeah, that's true. Being beyond their ultra virus or something like that, then they wouldn't be covered. Yeah.
Second. We need a roll call. We need a roll call. You're not gonna vote for this? No. All right, roll call.
Vice Chair Wildstreicher,
Yes.
Senator Sidnor,
No,
Senator West,
Yes.
Senator Muse,
No.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Washington,
No.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Pass.
Ask yourself.
Senator Carter,
Oh, no, I'm asking myself.
My vote counts twice then. The bill's gonna die, I mean, like, it's a huge step forward, but it's not gonna die, is it?
Hold it for a minute. Anyway,
You wanna get something to like the 10-yard line, or do you wanna get
What?
nothing? Like, you know?
well, I
You're
understand, but I
advancing-
don't think it's take it or leave it like that. And I think that some of the issues
It
raised,
certainly is.
some of the issues raised were legitimate issues. And so I think it should have been, we should have been able to have the latitude to flesh them out a little bit more. That's my honest opinion. I lean very favorable toward the bill, the idea of the bill, but there could be some things in here that are a little bit problematic, and that's real. So we still waiting on me? Well, it's already passed without me, right?
Will,
Okay.
no. Aaron Smith.
Yes. Strange things, man, strange things. All right. All right, we're gonna go to Senate Bill 603.
Senate Bill 603 authorizes a landlord to offer the payment of a fee in lieu of a security deposit in a residential lease subject to certain requirements. It requires a landlord to purchase certain insurance coverage using a fee in lieu of a security deposit. It establishes certain procedural requirements for a landlord and an insurer relating to certain insurance claims, and authorizes a tenant to dispute certain claims by a landlord, providing that claims by a landlord or an insurer are void under certain circumstances.
Legislated that they would have to.
So it would be an option that the landlord could offer.
They don't have.
They don't have to. They can still have the tenant pay a security deposit.
Okay, I just want to make sure that that's what it says, that they're not required to. But they may. Okay, thank you.
There was lots of unfavorable testimony on this bill, and I thought they made some good points. My note was needs a work group. There's been no work group. I don't think it's ready for prime time.
You know, this was an interesting bill because you heard the proponents and you're like, oh, that makes sense. This product is really useful for some people in certain circumstances. And then you hear the opponents, you're like, oh, that really makes sense. I can see why this product might be different than what we're used to, and could be abused under certain circumstances. But when you net this out, everyone who purchases a home has access to private mortgage insurance. That was a point I made during the hearing. And this is essentially an analogous product for rental properties. It's private mortgage insurance in the rental market. And this provides access to affordable housing for people who don't have the cash on hand to put down the security deposit all upfront, in the same way that mortgage insurance allows people who don't have 20% to put down to purchase a home. And so to me, this product is ultimately a good thing that increases affordable housing and allows people who otherwise aren't particularly liquid to get into housing and stay housed, and it provides that stability. So I just wanted to speak on behalf of the bill, on behalf of the product. I think it's a good thing, and I hope we move the bill forward.
Yeah, just a quick question. I mean, I like the idea. I met with the folks that on both sides of the issue. I guess I'm concerned with this fee, because the fee will be every month. A lot of folks stay in these apartments for 5 to 10 years sometimes. Some of my seniors, they stay in there. So they'll be paying that fee every month for 10 years, which would be more than their 2 months of income, 2 months of rent that they have to pay at a certain point. And so I guess I'm concerned by that. When does it end that they don't have to pay anymore because of that, because it goes over their security deposit? So I don't want them paying too long of this fee. So that's my concern.
Yeah. So presumably that would just be bargained in the contract for over the term of the lease. And you know, it's the lease lock, the company that testified, they had said that would be the amount over the course of a lease is generally a lot lower than what they would pay for a security deposit up front.
Okay.
Yeah, I know. I'm really torn on this bill as well. And I would sort of echo the first part of what Senator Waldstreicher said, which was you hear the proponents, you're like, why wouldn't we want this? You read the opponent's testimony in particular, and it seems like there's a lot of outstanding questions. And I'm reading in the Public Justice Center, and they were looking specifically for language related to what Senator Washington was saying, which is, what happens, can we write in there that if a tenant doesn't want to pay the fee, then they pay the full deposit? Like, how does that work? It sounds like there's a lot of questions that I don't know that we have the answers to. And so I'm just profoundly torn, because I would like to see a product like this on the market for times when it's necessary. I'm just not sure that it's certainly the advocates' questions haven't been answered. And finally, my specific question, which I think did come up in the hearing, but I couldn't find in my notes, so maybe council knows, is how many other states is this product already on the market in?
I don't have that information, Senator. I can try to get back to you on that.
That most states already have this and it's working. So that might calm some of our nerves.
46.
Yeah, so if we're an outlier, then maybe it's a matter of the advocates coming to understand it better who are in opposition.
Thank you. If
You think it's bad?
if
You think it's like-
this product is similar to what I remember, I think something like this was introduced in Baltimore City, if I'm not mistaken. I think the council president had introduced this, and it caused a real big hullabaloo in Baltimore City. And I believe I remember a lot of the advocates for tenants coming out, and it just becoming really ugly because they thought that tenants, this particular product could be used to take advantage of people who wouldn't quite understand exactly what they were agreeing to. And so I'm not, and I remember, I think when I first heard about it, similar to Senator Kelly, it sounds like a good thing, but then once you started hearing the opponents, it sounded like a trap. And therefore I'm not comfortable putting forth something that's gonna harm the tenants.
So the first question I have is, because this is a very long bill for what is a simple concept. So is there a model bill language, and is this model bill language?
I
That's my
don't
first
know.
question.
I don't know if it's model bill language.
And then secondly, I would just caution that I like the general concept, but I think when the judiciary in particular, and many other entities that have to pick up the pieces after we pass a bill that is not understood, that is ambiguous, that can be exploited. When they warn us of that, we should take that seriously, because when we think that it's easy for the courts to sort this out, I try cases all the time, and it's the worst experience for almost everybody I know. No matter whether I win or lose, they absolutely hate going to court. So hard on you emotionally, and that's hard on you financially. So I would just, ask for great caution when I think something like this could be worked out, but maybe just not this session. Thank you.
So I think that the one important element that's missing here, and maybe if you can tell me if I'm wrong, Shamari, is that there's no cap. There's no limit anywhere I see that says, like, either you can pay this, fee of, 2 months rent, or you can do this fee, which is equal to 2.5 times the normal deposit. But once you hit that mark, it's paid off, because like Senator Washington was saying, that it keeps going on. But even in here, it talks about a landlord's losses due to breach of lease. And then it talks about cost of repair damage by the tenant or tenant's family, agents, employees, guests, or invitees in excess of ordinary wear and tear to the leased premises. So literally they could charge for anything if they feel like you had one too many guests over.
Well, ordinary wear and tear is factual determination. It's legally what.
But they're put in here. The reason that it's got to be put in here for somebody's fancy, because it talks about that any extra damage basically done by your family, agents, employees, guests, or invitees in excess of ordinary wear and tear to the leased premises, which would include major appliances or furnishings owned by the landlord. So basically they're saying that if you have too many people, that you had too many dinners over there for Thanksgiving, and your oven goes bad, they could be like, well, you had too many people over on weekends, so you're the problem. So now you got to pay for this too.
I mean, they could say that, but that can happen with any residential lease. The landlord could claim damages that were beyond wear and tear. So
that's fine, but there's no cap on it, right?
It doesn't appear there's a cap. Lease Lock wrote in their testimony that typically the fee is $29 a month.
Yeah, but it can go on in perpetuity as long as they continue to lease the apartment.
Term. That's
If
not
they-
not the end of the person's residency. I'm sorry.
But if you re-up,
If you re-up, if you
still pay the fee.
you have the opportunity to pay to put down the security deposit, or to re-up
For the fee.
for the fee. Yeah, but at every end of the leasehold term, whether you move out or not, you have the option at each point in the process.
Thank you, Mr. Chairman. So as the great Karnak said, this is a very bad bill that is unfair to the tenants. They don't understand. I can't understand. They're not going to understand. And 2 years from now, we'll have a bill back in here trying to undo this fixed thing. It's not ready for prime time.
I reiterate.
We're gonna have a consent kill list sooner rather than later. All right. You gotta manage people's emotions. We got some work to do. Negotiations still pending on the floor, so again, we can do some 11th. Yeah. All right. Let us go. Let's pull up Senate Bill 292.
It's the C part of it.
Senate Bill 292, well, it does a couple of things. First, it alters procedures that a law enforcement officer in court must follow when there is reason to believe a child who has been detained is a victim of sex trafficking or a victim of human trafficking. Secondly, it prohibits the criminal prosecution of a juvenile proceeding against a minor for defined terms being qualifying offense. That's a defined term. Violation is a defined term in the bill, or violation of the prohibition on human trafficking. If the minor committed the underlying act as a direct result of sex trafficking, and it also adds offenses to the list of qualifying offenses for which a person may file a motion to vacate a judgment if the person's participation in that offense was a direct result of being a victim of human trafficking. There are no amendments in your voting packet.
Need to discuss this. Well, okay, then take the vote, but I'm a no. There's a whole lot. So we've dealt with this issue for a long time and I understand the empathy for this issue. But first of all, the way it's kind of sprung on us with, I mean, I don't know if any of you were privy to any conversations about it, but we have passed it in the past with an amendment. And I mean, I'm not speaking to persuade anyone, but I have real problems with moving forward on this bill and excluding so many other legitimate issues. The bill doesn't provide, I mean, the bill itself is probably poorly crafted, but in addition to that, we have so many other young people that we don't take into consideration. We have children that live in the home with their parents that are Senate children that are abused and neglected. We have children that are coerced and initiated into gangs. We don't consider them. We still continue to not consider the circumstances of everyone, and we take one category of people. And I don't think it's okay that we're moving forward and we haven't really had any discussion about it. I understand people are empathetic to the idea, but that's not okay because we already do have something in place. And to my recollection, the last time we had a conversation about this issue, no one could speak to any prosecutions or any prosecutions or non-prosecutions under the current law that we have. So, I mean, do what you will, but I have real problems with the fact that we're doing this based on an empathy toward the idea of we hate sex trafficking. I'm not even clear if this includes all other trafficking, human trafficking, sex trafficking, and labor trafficking. When I read it, it didn't say specifically human or labor. It said, I'm not sure it said all of them, but it's a real issue. And I think at the very least, I'd like the courtesy of an opportunity to go through the bill and look at where it might be able to be improved. And I'm very serious about that because we have, this is, I think, a second step from the vacature that we passed. We didn't just like willy-nilly pass vacature. We took time. We discussed it. We like figured out how to improve it. And I don't think it's okay to just like quickly move on this bill. So I'm asking for a hold.
So this isn't something that hasn't been on anybody's radar. With all due respect, we've all had time. We heard the hearing. We've had time to look into this. This has been something that's come up many times before, and it does reference a victim of human trafficking and sex trafficking. While I understand and appreciate the value that you're looking at other of those that are affected in our communities that should be potentially included in this, that's fine, but that's a different bill and that's for a supplemental, that's for the next time. We don't have that bill in front of us. We had a hearing on this bill and we have it focused on this group, and the fear, and this is about the fear of prosecution and them being able to come forward and be safe. So the numbers you're looking for aren't going to be found because they're not coming forward because of the fear. So I agree with what you're saying. I understand, but that's not this bill.
Where?
About with the sex trafficking. You're talking about they're worried about the fear of prosecution.
But who's not coming forward? What do you mean?
You asked for numbers to support this, and their numbers aren't, you can't measure the numbers of it because we don't have people that right now they feel that if they are in violation of this, they would be prosecuted. That's what this is about, giving them safe harbor to be able to get out of that environment, not worry about the being prosecuted for trying to get out of that environment and the people that are victimizing them. So this is a
Allegedly.
good bill and we can add to it next year or whenever, but this bill specifically is about human trafficking, sex trafficking, and this is the things that we're talking about. This is a good bill as it sits to move forward. So with that,
I
I
appreciate your
would,
sentiment, but I'm asking for the courtesy of a hold. I want to look at the bill more and I have a potential amendment that I've already thought about.
If the chair is fine with the hold, I'm fine with a hold as long as we feel like there's time left. I think that there is, right? And I think that the courtesy of a hold is. Okay, so I do think that we have had on this bill on the voting list before, so I'm not surprised to see it up here, and I prepared myself for it. For I think 3 times ago it was on the voting list and 2 times ago it was on the voting list. So, but I respect the senator and I agree. And if I'm new to this committee, so I'm a little bit unfamiliar with process, but I think it's appropriate to take time, walk through the bill, understand what it does in the next voting session, consider an amendment if you have one to offer. But I would echo Senator Folden that this is a priority, and I think it's really important for us to make sure we get a vote on this bill this session.
Against the bill. But I do remember going through it last year and feeling strongly that there were areas that need to be tightened up. So I apologize that I didn't go through it in detail before this particular voting session. If that's a problem for people, I do think we have time and it's not a delay tactic. I really think it's a possibility to making the bill better. And that's that's my honest belief.
like, this is the time.
Okay.
We keep.
And
We keep the.
and practically, it's a good bill, and I want to see it have a chance to pass. I don't want it to pass without your comments and where you are and what concerns that you have.
So look, let me just ask you guys a question. Like, this is a very important bill and I completely agree with you. But for instance, like, everyone here knows exactly what crimes are qualified under this bill? Do you know exactly what crimes are? If you can't answer that question, honestly, then you should not be voting on this bill. Okay, so that's one thing that we definitely need, folks to study. I agree. This bill is very important. We will get it done, but like one simple question, just like that. That's the thrust of the bill, and not everyone in this room can answer that question. And so that's a big deal. Okay, so Senator asked for a hold, we'll hold it. We are going to get this bill done. We will pass this bill, but everyone deserves a chance to kind of deep dive into it and understand, have your eyes wide open what we're doing exactly. Senator Kelly.
Sorry, and again, just because I'm new to the committee and I appreciate the process, and I think everyone's in the same place with wanting a thorough process on this bill. So timeline wise, if we're holding it, should we prepare to your point, to make sure, do we want to have time set aside perhaps with the advocates to answer questions for members? What can we do to make sure that the next time this bill comes up, which I'll assume is at the next voting session? Is that not true?
It's already in the works. I've already been in touch with Joyce King and a couple other folks that were already working on it.
So it might be in 2 voting sessions, and we shouldn't be surprised if it's not on the list the next voting session.
No, we'll keep it on for discussion, but we're trying to get this done as soon as possible, but probably tomorrow morning. Yeah, 9 a.m. tomorrow morning, probably. So
Perfect. No, and I think it's wonderful. I think
Yeah.
I love to see this committee working more thoroughly, because to your point, Mr. Chairman, we should be able to answer questions about important bills like this as we pass them out.
And
Thank you.
that is the simplest question to ask, but all right. So we're gonna hold it, and we'll come back 9 a.m. tomorrow. We'll knock it out. I mean, we're moving. All right. Well, let's then. Yeah, there you go. You and me both. All right. So let's go to Senate Bill 36.
Divorce, yep. Senate Bill 36 repeals the authority of a court to grant a limited divorce and alters the grounds for an absolute divorce. Specifically, under current law, the grounds for an absolute divorce are adultery, desertion, commission of a felony, 12-month separation, insanity, cruelty of treatment, and excessively vicious conduct. Under the bill, the grounds would be a 6-month separation, irreconcilable differences, permanent legal incapacity, as well as mutual consent. And the bill additionally clarifies that for the purposes of the 6-month separation, the parties need not live in separate dwellings.
Thank you, Mr. Chairman. I'm looking, there was no unfavorable testimony on this bill except for Mr. Vince McAvoy. Other than that, everybody was favorable. The House passed this bill unanimously. And this is, I think the council just described it well. The last thing is we just passed a bill 2 weeks ago on registered domestic partnerships, which provided that the registered domestic partners could separate for 6 months and then get a termination of their relationship. It would be weird if we let them terminate their relationship after 6 months, but required married people to continue for a year after they've separated. So this would bring this bill into conformity with what we passed 2 weeks ago.
I'm going to stand up for marriage. I think this bill is wrong. And giving another 6 months for the process to work out where we can do reconciliation. We are not talking about somebody who has been, they have an issue where they don't feel safe. Then they need to call 911. We have avenues to be taken that. But I just think marriage is sacred. I think we need to be honest about it. Not that it's not being honest, and let me take that back. I apologize. But I think we ought to give the institution, it's a year of people who need to go through reconciliation. If that's not happened, we have a process at the end of the 1 year. I'm done. I won't say anything on the floor. Just
I'll say when I initially heard the bill, I was probably closer to Senator McKay than I was to Senator West. But after talking to a few of the advocates and things about it, the reality is if two people don't want to be together, why are we going to make them be together? So I understand God. I understand. No, I do. So.
Thank you. We get all the fun issues here on this committee, don't we? While I definitely empathize with Senator McKay and his point, I will speak from the perspective of my children and in defense of divorce. And I'm divorced and remarried. I will say that 1 year period of separation that was required was the hardest for my children. And I think that 6 months is really better when you're talking about how to get children through the process of a divorce and into improving the lives of their new families. For the sake of my kids, I would certainly be eager to support this because what they went through with what Maryland law required when I got divorced was traumatizing for them. And I think that this is fair, reasonable, and it makes sense both economically for the parents and for making things better for families that are going through a difficult situation.
Yeah, I just wonder if there's any other state that goes lower than the 6 month separation. Like, why the 6 months?
Well, so the 6 months is currently required for a limited divorce. So I think the way the bill works, it just gets rid of limited divorce and makes the absolute 6 months. I don't actually know off the top of my head about other states. I'd have to get back to you on that.
Okay, thank you. Two things. One, and I agree with you, while marriage is sacred, that's relative, that not all persons who enter into a marital a covenant understand that nor take it that way. I have to look at it from two perspectives. And I'll use this. It was a couple in my church and they were having problems, set up for counseling. We were trying to figure out what was going on. One Sunday morning, they were sitting in church, and then Monday night, we got the call that he killed her and killed himself. We did not have the chance to make any recommendations, not my staff, they would just hearing and passing it along. Time handles some things. When you surrender, if you surrender your life to him, things get better. When it's in your hands, it makes it irrelevant. There's civil marriage, there's sacred marriage as we now see it today. And having said that, and just from my own experience, when people make up their mind to do something, you can either push them one way or the other. Sometimes, and most of the time, it's worse when you say you have to stay together. I believe in marriage. I believe it is sacred as far as I'm concerned, but I can't impose it on everyone else. And looking at this, I'd have to give the benefit of the doubt and support it. For example,
For example, when somebody feels threatened, they have the ability to get divorced in a quicker time. It's just taking it from those who, when they don't both agree that they want to be divorced, waiting the year period and
And
bringing
we-
it down to 6 months.
got you. I understand, I agree with you, but what are we waiting for? We're waiting for 6 months for what? And we're waiting why? On what evidence are we waiting to know that it's going to get
I
better
just-
or
I
worse?
just tend to
Or is it
believe-
just waiting to be waiting?
I just tend to believe that when two people chose to get married, they took time and effort, probably more than 6 months, to plan the wedding. Or up to a year to plan the wedding. I don't know why we have to jump to get out. Now, don't get me wrong, the young lady who came and gave her testimony, I was quoted, I even said here, the guy's a dirtbag, I get that. But that's one example, and I just don't believe that we put so much thought and education into getting together in a marriage, because we can now get out 6 months earlier.
I struggle with
Quote
that,
the good senator in his presentation. Let's get it over with. And so anyhow.
And I hear what you're saying. And
I know where this is going.
Theologically and biblically, I do agree. But what I don't want on my conscience, and I came that close to having it, is saying to this couple that did what they did, and it wasn't the first time. They're gone. If I had my way, I would have come that close to telling them, stay together and work it out. And the outcome would have been exactly what it is. And I would have been responsible for
Right,
telling
and
them.
I don't know
stay
all the
together.
details, but and
I understand.
don't need to know all the
No,
details.
but thank you for,
But I'm not exactly sure that is apples to oranges here.
okay, thank you.
So we'll just agree to disagree.
No,
Love you, brother.
always, you better believe it. That's my brother over there. Don't mess with him.
Drive a bus over me and back up.
Thank you. Thank you, Mr. Chair. My question is akin to Senator Washington. Just a couple of questions. First of all, I want to clarify. I think council said it, but now I'm reading it. I'm not seeing it, but this does two things. It shortens it to 6 months. And then is this also the bill that says that you don't have to leave the house? Or is it a different
Yeah,
bill?
so you could live separately and that doesn't necessarily mean that you're not separated, correct?
So I do have just a question, and again, it's not with any motive, it's just a real legitimate question. What was the rationale for the 1 year? What's the rationale for the 6 months? And to those that say, why should you be forced to stay together if you want to? Why have any period? Why can't I just say, I don't want to be here anymore and go file for a divorce? Like, what's the rationale behind the time period?
Well, the 1 year we have right now is an arbitrary decision to establish 1 year. That came a couple of years. Before that, you had to go into
When-
court and prove grounds, adultery, and you had all this messy testimony talking about in hurting the kids, to put the parents through that. And so as a way out of that, the 1 year was adopted some years ago. It was an arbitrary number. And
As is the 6 months, would you say?
as is the 6 months, there's no science behind it, but the conclusion I really respect my fellow senator's viewpoint. My wife and I have been happily married for like 35 years now. And it's great. Would that all couples were happily married? My father was not. He got married at the beginning of the Second World War to a woman very rapidly, and then learned that she'd been in and out of psychiatric institutions most of her life because her behavior after they got married became intolerable. He knew very quickly that he needed to separate permanently, but he was Catholic, and I won't go into all that. That was a problem. Fortunately, he got out of it. But some people live happily a long time. Some people live unhappily quickly. Others, the marriage deteriorates as time goes on, and then they separate.
So to
You started
reiterate-
up as by being concerned about people under the same roof.
Washington's question, like, does anybody know, is 6 months common, normal, or is that others in line with other states?
I was on a committee when we dealt with it 10 years ago. And I remember Jamie Raskin trying to answer the question from a constitutional perspective as to why it was a year. And it all boiled down to, it was a compromise, it was a compromise so that you don't look at it as being not sacred and you don't look at it as, on the other end of the spectrum, as being something that could be potentially dangerous. It was definitely a random number without any reason except just kind of compromise between those two extremes.
Thank you.
I guess, what Senator Carter was asking you, and I guess you've answered it, which is that the 6 months is just something related to the limited divorce. Talking to Senator West. But I do want to clarify something. It used to be that it would take you about 2 years to get divorced, and I'll tell you why. It was not an arbitrary number. It was in the law to slow people down, and generally, people are generally people who have major life changes. Psychologists, it's somewhere between 1 year and 2 years that you absorb it, can deal with it. And so the idea was to just get people to really get the gravity of the decision and to mull it over and to try and figure out whether this was the right thing to do. Social pressures, demise of marriage, conventions and all of kind of things. And I guess even competing with states that do quickie divorces, we brought the number down, but do not think that that number was arbitrary, because it was not. Historically, it was not.
2 years may not have been, and I apologize for saying it wrongly. Raskin is a constitutional lawyer, but he was giving his interpretation based on Maryland law. And I don't know about the 2 years, but the 1 year was arbitrary. It was to try and do exactly what I hear you saying, to give people time to think it out, to give the church time to say, okay, we've done something to try and hold on to what we know is sacred and what we believe is sacred. But the 2 years, I don't know, the 1 year, and that's exactly what we asked and what we struggled with. And we could find nothing that would support anything other than it was a year, it was a compromise. It wasn't just throw it out the window, and it wasn't just let it go on forever. That's basically what it was 10 years ago.
All right, well, I had more questions, but thank you. I think the better adjective for it was a compromise as opposed to being utterly
That's what I said.
arbitrary. I don't think it was arbitrary.
No, I said compromise.
So Senator West, I'm trying to figure out, did a group of people work on this bill? Did you look at other states? Was there any discussion about the downside of this? Will there be pressure for us to shorten this period even more? There are states that really, I think, can get divorced even quicker. I'm just wondering where the public policy behind this is, what the intent is, and what you think the future is.
Let me take the second question first. I don't intend to go any lower. It seems to me 6 months is a fair
I
time.
didn't ask about you personally.
Yeah. Oh, but in terms of working on the bill, Dorothy Lenig is here. She's led a group that's been working on this for some time. Is it permissible for her to briefly address this on how long she's been working on this?
Sure.
Who's Dorothy?
We have 4 minutes to get out here, and then I want to make sure Senator Kelly go ahead and chime in first. And then.
I'm going to cut you off from answering questions. I just wanted to answer the second part of Senator Carter was asking about the not having to live separate and apart provision. And I just wanted to say, again, in my experience, having gone through a very difficult and painful divorce, the living separately imposes some really unfair economic burdens on families that are trying to go through a divorce. And so this really, I think, in situations where it's appropriate and amicable, right, it can be an option that is very helpful if you're living in the same residence, but not in the same bedroom, and just living like roommates while co-parenting. It can both improve the parenting relationship through the divorce, and it can, make the transition a lot easier for the children. So I think that that's really important that we have that option available in Maryland law. The other thing I was going to do was move the bill favorable. So I'll go ahead and do that before my mic is gone and see if anyone wants to second it while we go to Dorothy. Thank you.
Okay, so I just want to say, this was a work group of the State Bar Family Law Section Council. They worked on it for several years and came up with this bill. The 6 months, I think it was kind of a compromise. They wanted it to be less than 1 year. It was what the limited divorce was. The only other state I know about is Pennsylvania, where in 1980, you could get divorced after 3 months under certain circumstances. So I don't think we will be outliers, but honestly, I only know because I did. And I'm way better off for it. So thank you. I think this is an important bill.
Do we need a roll call? Let's do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
For favorable.
Senator Folden.
Yep.
Senator James.
Yep.
Was that a yes?
That was yes.
Okay. Senator Washington.
Yes.
Senator Kelly.
Yes.
Senator McKay.
Nay.
Senator Carter.
Yes.
Chairman Smith.
For divorce, I guess. I don't know. Yes. That's it. Yeah, or a quickie divorce. I don't know. All right. All right. So the bill passes 10-1. See you all on the floor.